morning, this is your Kelso Report for Tuesday, October 18th, and I'm your host, Clark Kelso. Well, yesterday the Ninth Circuit in bank issued a decision in Mattis v. Agorano on the doctrine of qualified immunity involving the use by police officers of tasers during relatively routine engagements. In both cases that were consolidated for the in-bank, the majority found that the officers had used excessive force, but that in both cases qualified immunity still attached because the law, as of 2004 and 2006, was not clearly established at the time these events took place. Now, the law on qualified immunity is fairly well settled at this point. Qualified immunity protects government officials from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. In other words, there are two analytic questions. First, whether the officer violated a plaintiff's constitutional or statutory rights. And second, whether those rights, if any, were clearly established in light of the specific context of the case at the time of the events in question. The Supreme Court has indicated the lower court should use their sound discretion in deciding which of the two prongs of the qualified immunity analysis should be addressed first, so that courts do not prematurely address the merits of speculative constitutional claims when, even if a claim now may exist, it most certainly was not clearly established when the events took place. In the first case before the in-bank panel, the plaintiff had been stopped for traveling 32 miles per hour in a 20-mile-an-hour school zone, a minor traffic offense. She refused to sign the speeding ticket and also refused to get out of her car when instructed. She did not pose an immediate threat to the safety of the officers or others. She actively resisted arrest only insofar as she refused to get out of her car when instructed to do so, and stiffened her body and clutched her steering wheel to frustrate the officers' efforts to remove her from the car. She did not evade arrest by flight, and no other exigent circumstances existed at the time. She was 7 months pregnant, which the officers knew, and they tased her 3 times within less than 1 minute, inflicting extreme pain. The second case involved a situation where officers had been called to a house in response to a domestic abuse 911 call. When they arrived, there was no obvious violent confrontation going on. They entered the house to talk with the victim who had called for help. She happened to be standing between a police officer and her husband when the police officer moved forward in an attempt to arrest the husband. At that time, when the officer brushed up against her, she put her hands up to protect her own body from the officers, at which time he tased her without warning. The majority held the officers used excessive force in these circumstances, both in the first case and the second case. However, in both cases, the court held that the case law on use of tasers was not so clearly established when the events occurred in 2004 and 5, so that a reasonable officer would have understood that what he was doing constituted excessive force under the Fourth Amendment. I think under today's version of the law, it is clear that this would have been excessive force, so this is a qualified immunity that's good for the officers in those cases, but on a going forward basis, I think officers need to look out. Well, that brings us to our 2 one-liners for the day, the first in the area of commercial law. In First Bank versus East West Bank, the Second District held that 2 deeds of trust secured by the same real property, which were simultaneously time-stamped for recording by the Los Angeles County Recorder's officers, gave the 2 lenders equal priority, even though one of the deeds was subsequently indexed before the other. For the court, the key question for priority was the timestamp, and since both delivered their trust deeds to the recorder's office before business hours on September 4th, and both received the same timestamp of 8 a.m. on September 4th, both had the same priority. How often is that going to happen in a first-in-time filing system? Next, in the area of family law, in Hogue versus DJ Mahor, the 4th District affirmed the decision of the trial court to grant visitation rights to a grandparent over the surviving father's objections to visitation. Now, the United States Supreme Court held in Troxel v. Granville in 2000 that the courts are to presume that a surviving parent's objection to grandparent visitation is in the best interest of the children. In Hogue, the court held the presumption was overcome by evidence that the surviving parents' claimed reasons for objecting to visitation were both unreasonable and not credible. In essence, as the surviving parent practically admitted on the stand, he objected to visitation mainly to spite the grandparent, even though he admitted that grandparent visitation would be in the best interest of the children. Well, we've got 4 cases in which the United States Supreme Court yesterday granted review. Let's take a look at those. First, in Mohammed v. Rajoub, the Supreme Court granted review to address the question of whether the Torture Victim Protection Act permits actions against defendants which are not natural persons, organizational defendants. The issue arises because the statute refers to, quote, an individual who subjects an individual to torture, close quote. And of course the word individual usually means a natural person as opposed to an organization. In the second case, somewhat related issue arises. Kiobel v. Royal Dutch Petroleum, the court granted review to determine whether the Alien Tort Statute applies to corporations or only to natural persons. The statute in this case provides that, quote, the district court shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States, close quote. So the question is whether an organization can violate the law of nations or treaties. The third case is a government law case involving personnel actions in Elgin v. Department of the Treasury. The plaintiffs sought a declaratory judgment and injunctive relief based on their termination as government employees because of Section 3328 of Title V, which imposes a lifetime bar on federal executive agency employment on men who do not register with a selective service between the ages of 18 and 26. Plaintiffs challenged the statute on equal protection and bill of attainder grounds. But the issue before the court is whether federal district courts even have jurisdiction over constitutional claims for equitable relief brought by former federal employees, or alternatively, whether the Civil Service Reform Act impliedly precludes that jurisdiction. This is a big case dealing with the scope of the Civil Service Reform Act's enactment, just how broad is its preemptive reach. And the final case where the court granted review involves the First Amendment. In United States v. Alvarez, the court granted review of a Ninth Circuit decision which struck down on First Amendment grounds a statute which makes it a crime when anyone, quote, falsely represents himself or herself, verbally or in writing, to have been awarded any decoration or medal authorized by Congress for the armed forces of the United States, close quote. In other words, it's a crime to falsely represent you've got a military medal. Ninth Circuit struck that down on First Amendment grounds. I tell you, I'm thinking the court's likely to reverse this particular Ninth Circuit decision. I think it's just a question of how large the vote will be for reversal. And that's it for today's Kelso Report. Have a great day in the law.